This hearing is being conducted by Zoom. The attorney is Sarah Barber, appearing from her office, and Mr. King, civil prosecutor, is appearing from his office, both by Zoom. Ms. Barber, you and your client both agreed to this matter being conducted by Zoom rather than an in-person hearing. Right, and that's right for you, Mr. Murray?
Yes, sir.
All right. Now, if you need to talk to your attorney at any time, Ms. Murray, since you're not in the courtroom sitting next to her, if you need to talk to her, just let me know, and I can put you and her into a breakout room with the two of you talk, no one else will be able to see you here, okay?
Thank you, sir.
All right. Now, Murray, I've been presented with plea forms of plea of guilty in each of these two cases. These are forms prepared from the prosecutor's office. The first one is 21-0196. I'll hold that up to the camera. Do you recognize that plea of guilty with your name on it and case number?
Yes, I do, Your Honor.
And on page 3, there are signature lines. There's a sentence that says, "I enter this plea voluntarily," and then right underneath there is probably the best signature I have seen in about 10 years. D.A. Murray, the May 10, 2022 date, totally legible and clearly written. That's your signature?
Yes, sir.
All right, well, on my compliments, so you have the best signature I've seen. And then on the other case, the same thing, and on page 3 is that's your signature in the 22 CR81 case.
Yes, sir, Your Honor.
All right. Now, this, when did you sign these agreements, Mr. Murray?
I signed them this morning.
And Ms. Barber go over each of them with you and explain it to you and answer any questions you have?
Yes, you did.
And when you signed them, did you understand they were agreements to plead guilty, which means it would not be a trial in either case, and the next step in your case would be a sentencing hearing?
I totally understand that.
And do you think you had enough time to fully consider this matter before you made that decision? Do you think you had enough time to fully consider the matter before making the decision to sign the agreements?
Yes, I did.
And did you sign each of them voluntarily?
Yes, I did.
And you're still wanting to go forward with those agreements now?
Yes, I did.
Now, each of them say that you're going to plead guilty to the first count of aggravated possession of methamphetamine. In each case, under 2925.11 Higher Code, 5th degree felony. In each of the cases, it states on page 1 that you understand the maximum penalty for the case charged in that case is the same. 12 months is the maximum prison term, 6 is the minimum if there's a prison term imposed. There could be a fine of up to $25, but there could also be license suspension, 6 months to 5 years. You understand that?
Yes, I do.
Under the law, Mr. Murray, if you're convicted of both offenses and sentenced to prison, those sentences could be ordered to be served consecutively, meaning one after the other. That means that it could be a total sentence of 24 months, a total fine of $5,000. You understand that?
Yes, I do.
And do you have any other felony charges pending against you anywhere else?
No, sir, I don't.
Are you currently on probation, community control, post-release control, or parole from any jurisdiction? Right now, under the law, Mr. Murray, if you're convicted of these offenses, should you be sentenced to prison? Once you complete the prison term imposed by the court, the law provides that the adult parole board may, at their option, they think it's appropriate to put you on what's called post-release control supervision for a period of up to 2 years. And if they do, you'll be supervised on the terms that they set. If they determine that you've not applied to those conditions, then they can return you to prison, make you serve an additional period of up to 9 months for a single violation, but there's a cap, a limit of cap for every prison term is served for all violations. But if you commit a felony under post-release control supervision, then in addition to whatever sentence the judge in the new case proposed upon you, that judge could also sentence you for committing that offense while under post-release control. In this case, to an additional period of 1 year or time left on the post-release control period, whichever is greater. That occurred, that would be served consecutively the sentence in that new case. You understand that?
Yes, I do.
Now, under the law, I'm not required to send you to prison for these offenses, Mr. Murray. I can impose what's called non-prison or community control. And that means that instead of going to prison, you're put under the supervision of a probation officer for a period of up to 5 years for the term set by the court. If during that period of time the probation department feels you're not compliant, then they file a written up with the court, serve a copy on you, there's a hearing, and you you have a right to have an attorney to represent you at that hearing. If the outcome of that hearing is that you have failed to comply, then at that time, the court would revoke your duty control and send you to the 24 months and fine you $5,000. You understand that?
Yes, I do.
Right now, in case number 21 CR 196, the indictment reads that on or about April 3, 2021, in Highland County, Ohio, you did not obtain, possess, or use a Schedule 2 controlled substance with methamphetamine, violation section 2925.11 Firearms Code. And then the other case, 22 CR 81, is the exact same language that says that it happened on March 16, 2021. Otherwise, it's the same offense. Now, do you understand what the state has accused you of having done in each of those cases, when, where, and how they alleged that you did the act? And you discussed the nature of each charge, the evidence in the case, possible legal issues in each case, possible offenses. You might try to raise in each case trial and possible outcomes of a trial with your attorney.
Yes, I do.
And are you satisfied with your advice and confidence in this matter?
Absolutely.
Are you under the influence of any types of drugs or alcohol at this time?
No,
Has anyone threatened you to make you plead guilty here today?
no.
Now, on page 2, about 2/3 of the way down on each plea agreement, there's a couple of sentences that are printed in bold and underlined that read as follows. Defendant shall enter a plea of guilty to the indictment. State defense shall only recommend community control, and that defendant be referred to drug court. Is that your understanding of the agreements?
Yes, I am.
Has anyone promised you anything other than that if you plead guilty here today?
No.
Under the law, the matter of sentence is up to the judge, not to the parties. So even though there's an agreement that you should get community control or probation and be evaluated for possible admission to the drug court, the court is not bound by that recommendation. So if you plead guilty, once I've looked at all of the information submitted, I decide that's not the correct sentence, I could end up sentencing you to prison for as much as 24 months and fining $5,000. You understand that?
Yes, I do. Your discretion.
All right. Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
I do.
Right. Now, you have certain rights, you understand, Mr. Murray, before you can accept the plea. First, you have a right to have counsel. Ms. Barber appointed to represent you in these cases. Now, that wasn't said to work the case out, but to provide any defense that might be available to you under the law that you would like to provide. So, if you decide not that you don't want to do this, that you'll continue to defend you, represent you, including a trial, if that's what you want in either of both cases. You understand that?
I do.
Right, now, Mr. Murray, each of these cases, you have a right to have a jury trial in which 12 people will be selected from a group of citizens of Highland County that are summoned for jury duty on your trial. After the 12 jurors are selected in each case, the evidence will be presented and then they'll be instructed on the law. And that jury will have to decide in each case by unanimous verdict between all 12 of the jurors in that case have to agree whether the state is moved together. Now, if you didn't want to have a jury trial, if you didn't want to plead guilty, you could waive the right to give up the right to have a jury trial, and in that case, you have to hold a court or bench trial, which means that instead of the jury hearing evidence, it's the judge who hears the evidence, applies law, decides whether or not the state proves the evidence, we're going to read it back. You understand that?
Yes, I do.
Now, under the Constitution, Mr. Murray, in each of these cases, you have a right to confront the witness issue, cross-examine with your attorney. So what that means is that the witnesses in each case have to come into court, testify in front of you, your attorney, and anyone else is present. If the prosecutor doesn't ask you questions, your attorney can ask questions. That's called cross-examination. The purpose of that would be to bring out evidence to help your side of the case. You understand that?
Yes, I do.
Now, under the Constitution, Mr. Murray, you have the right to use the power of the court to compel or force witnesses to come to court to testify with you, like you state. So if you have witnesses who are uncertain when you come in voluntarily, your request for issue court order is called subpoena. And force those people to remain in that subpoena, the court will be able to testify if you wanted them to, but they won't be here. Which is the same way the state witnesses are forced to come in court to testify against you. You understand that?
Yes, I do.
All right, now under the Constitution, Mr. Murray, you have a privilege in each case against self-determination, which means that you cannot be held or forced to testify in either case at any time by anyone. And in fact, no one's even allowed to comment about it, except in one situation. If you decide not to testify in either of those cases. The judge would instruct the jury in that case, that because that is your constitutional right, you cannot consider that you did not testify for any purpose. You understand that? The Constitution, Mr. Murray, you are presumed innocent until proven guilty by the state of Ohio in every essential element of each offense in each case. What that means is the burden of proof is on you to try to show you're not guilty simply because you've been charged. In fact, under the law, you don't have to present any evidence for your own defense at trial at all. You may, but you're not required to. Whether you do or not, the burden of proof remains on the state of Ohio to prove your guilt. Every essential element of the offense charged are proved beyond reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes, I do.
And now, originally you entered a plea of not guilty. The not guilty plea denied the allegations of the indictment, denied that you committed any crime in each case, and exercised your rights in each case, as I've just described. Now, if you change your plea from not guilty to guilty, which is two cases, that is the opposite of not guilty. If you guilty plea, and this the allegation in the indictment, and this is a crime, and that you committed that crime. And that plea waives, gives up all the rights that I've just described for you here today, except the right to have an counsel. You always have the right to have an attorney, no matter what you plead. But with that exception, in each of the two cases, your plea of guilty would waive, give up your right to have a jury or court trial. It would waive, give up your right to confront witnesses against you in court and to cross-examine for your turn. Waive, give up your right to use the power of the court to subpoena or force witnesses to come into court to testify on your behalf, the same as the state. You waive and give up or privilege of self-incrimination because if you say you're guilty, that's what she finds guilty. They also waive, gives up your right to require the state to prove your guilt because if you say you're guilty, then the state doesn't have to prove your guilt. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up your right to file an appeal on any alleged violations of the rights you feel may occur up until this point in the case. Now, if I sentence you to maximum sentence or other circumstances you file an appeal, that would have to be filed within 30 days of your sentencing after being filed. You understand all that? And are you a U.S. citizen, Mr. Murray? All right, and do you have any questions about the charges in either case or the possible penalties? You understand? Do you have any questions about the plea agreement in either case? You understand? Any questions about the constitutional rights I explained? You understand those? Have any questions about the plea of guilty, what it means, what will happen if you enter that plea in these two cases? Okay. Now, is there anything you'd like to speak with Ms. Barker about before we go any further? All right, so you have no questions at this time? All right, then is it your decision to withdraw your not guilty plead guilty to the charge in each case pursuant to the terms of the agreement that we have just gone over?
Yes.
Okay. Then in case number 21 CR 196, it alleges that on or about April 3, 2021, Highland County, Ohio, he did knowingly obtain, possess, or use a Schedule 2 controlled substance with methamphetamine, violation section 2925.11, Ohio Code charge, aggravated possession of methamphetamine, 53 felony, very possible prison term, 26 to 12 months, possible fine up to $2,500, possible license suspension 6 months, 5 years out of plea. Then in case number 22 CR 81, which alleges that on or about March 16, 2021, Highland County, Ohio, he did knowingly obtain, possess, or use a Schedule 2 controlled substance with methamphetamine, violation 2925.11, Ohio Code, also a 53 felony, same penalties. How do you plead? All right. The court finds on this day, the court defendant was advised of all his constitutional rights. They no intelligent voluntary waiver, same as Article 11. Please accept an order filed. Defendant is found guilty of the offense as set forth in each case. The matter is referred to the Police Department for a precinct investigation, which will include an assessment for substance use disorder treatment and or mental health assessment. Sentencing will be set. Are you still out on Wednesdays in Adams County? Okay. But June the 7th at 1 p.m. Could you go grab it? I just checked that. I had talked to them for sure. Open in the afternoon. I know I'll open in the morning. I've got that point. Now I'm going to refer the matter to the drug court docket, and that is something that you'll meet with Ms. Virgil or Ms. Davis about. That is something that you will have to decide whether you want to apply for or not. The court doesn't order people into that program. The court has to see an application and then decide whether or not you meet the legal criteria, whether that's the most appropriate disposition of your case. They'll go over with you and feel free to ask them any questions you want, and it'll have all the conditions and so forth on it. All right, good. All right. So it'll be June the 7th at 1:30. That's Tuesday afternoon. Okay. On to be continued. All right, is there anything further, council? All right, thank you. Okay, you are Jared Hill sitting there with on the screen says Jared Hill?
Yes, sir.
All right. Case number 22 CR 36, State of Ohio versus Jared R. Hill. Where are you currently from, Mr. Hill?
I'm sorry, can you start this?
Okay, all right. This hearing is being conducted by Zoom. Mr. Hill's attorney is Sarah Carter. She's appearing from her office, and an attorney on behalf of the state is the assistant prosecuting attorney, Adam King, prosecutor's office. The defendant is charged in this case with aggravated trafficking in methamphetamine and aggravated possession of methamphetamine. Both of those are, I'll take that back. Count 1 is a 4th-degree felony. Count 2 is a 5th-degree felony. Now, I have here a interesting, it's a copy that's got a little frame around it. I don't normally see those. But this is an entry that, or a plea guilty form that indicates you're going to plead guilty to count 1. So I'm going to hold this up to the camera, Mr. Hill, so you can look at it. And you recognize that as being the first page of the plea agreement form, has your name, case number, and the charge.
Yes, sir.
Now, this is a 3-page document. On page 3, there are some signature lines. And just about a third of the way down the page, there's an I entered the plea voluntarily, and I see what appears to be the signature of Jared Hill, dated 2/28/22. So I'll hold that up on the screen and ask you if that is your signature. I'm sorry?
The date is incorrect, Mr. Gilbert, it's not the wrong date.
Oh, okay, so what date did he sign it?
April 20th.
Oh, okay, April the 20th? Okay. And where was that you signed this, Mr. Hill?
I was in Salt County, Justice Center.
Okay. And did you talk with Miss Barber and after explaining everything to you before you signed it?
Yes, sir.
All right, and when you went over this, did you understand everything in it?
Yes, sir. I was aware that
Okay. so? You will enter into this agreement voluntarily?
Yes, sir.
Okay. Now, the agreement states that, page 1, is you're going to plead guilty to count 1, the aggravated trafficking of methamphetamine, a fourth degree felony, under 2925.03A1. Further states that you understand that the maximum penalty for that could be 18 months in prison, minimum 6 months in prison, if the prison term imposed. There could be a fine of up to $5,000, could also be a license suspension, 6 months to 5 years. You understand that?
Yes, sir.
Now, other than the charge you're currently in STAR for, are you facing any other felony charges anywhere else?
Yes, sir.
And which county are you in STAR from?
It's, county,
All right, for, tell me what court? Court. Okay, it's a previous case out of this court.
Yes, sir.
Okay, all right, gotcha. And somebody refresh my memory, how long ago was that he was sent down there?
Basically, similar probation violation within the last couple of months, I believe.
Okay.
Yes.
Okay. Okay, all right. Now, if you should be convicted of this offense, and if you should be sentenced to prison on this offense and on the other offense, if you violate community control, then those sentences will be served consecutively, meaning one after the other. You understand that? Now, other than the charges out of this court, are you on community control, probation, parole, or post-release control in any jurisdiction? Now, under the law, Mr. Hill, if you are convicted of this offense, and if you are sentenced to prison, once you complete the prison term, the adult parole board has the option under this law to put you under what's called post-release control supervision for a period of up to 2 years. They don't have to, but it's up to them, they make a decision. If you are put under post-release control supervision, then if they determine that you have failed to comply with any of those conditions that they have set forth, then they can return you to prison if you serve a additional period of up to 9 months for one violation. But there's a cap of where a prison term was imposed for all violations. Now, if you commit a new penalty while under post-release control supervision, then in addition to whatever sentence the judge in that new case imposed upon you, the judge can also sentence you for committing that violation while under community control in this case, to an additional period of 1 year or whatever time is left on that 3 years post-release control, up to 2 years post-release control. Whichever is greater, if that occurred, that would have to serve separately the sentence in the new case. You understand that?
Yes, sir.
Now, the charge in count 1 alleges that on or about June 7, 2021, in Hyde County, Ohio, he did knowingly sell or offer to sell methamphetamine, a schedule 2 controlled substance, violation section 2925.03A1. So that's the charge of the fourth degree felony that we're talking about. Carrying possible prison term between 6 and 18 months, and fine of up to $5,000. Now, you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged that you did it.
Yes, sir.
And have you discussed the nature of the charge, the evidence of the case if possible? Defense you try to raise the trial, possible outcome of the trial with your attorney?
Yes, sir.
Are you satisfied with your advice and confidence in this matter?
Yes, sir.
Are you under the influence of any type of drugs or alcohol at this time?
No, sir.
Has anyone promised you or threatened you in any way to get you to plead guilty to this charge?
No, sir.
Now, on page 2, the agreement reads that the defense shall plead guilty to count 1, state will dismiss count 2, state defense is going to recommend community control substance abuse treatment, then agrees to repay $5 million behind time tax force the amount of $25. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty or today?
No, sir.
Now, under the law, Mr. Hill, the matter of sentence up to the judge, not to the parties. So even though there's an agreement between the two of you, the state and you, that you should get community control. Okay,
That's better, sorry.
all right. Maybe my mic's not up here, a little up here. Well, no, it's up high, I guess. Did you turn that volume? Okay, well, I'll try to keep my voice up. So even though, the agreement between the state and you is that you should get community control, if you plead guilty, I don't have to follow that recommendation. I could decide that you should, be sentenced to prison, for between 6 and 18 months and fined $5,000, and your license should be suspended for 26 months to 5 years. You understand that?
Yes, sir.
Right, now, do you hold any license or certification from any state agency, governmental agency that regulates any trade, occupational, or profession?
I don't know, but that could be considered, I got a welding certificate as I was.
Yeah, no, that's through a trade group, but, it's not a state license, like, pharmacy tech, or SDNA, or med tech, or Harvard, things like that.
No, sir.
Okay. Now, you have certain constitutional rights, as I understand before, I can accept a guilty plea from you, Mr. Hill. First, you have a right to have counsel. Ms. Barber is appointed to represent you, not simply to work the case out, but to provide any defense that could be available to you under the law that you wish her to provide. So, if you decide that you do not want to, enter this plea of guilty, that you instead want to defend against the case, to continue to represent you throughout the case, including a trial, if that's what you want. You understand that?
Yes, sir.
Right, now, under the Constitution, you have a, right to have a jury trial in this case, in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, and then the jury will be instructed on the law, and they will then decide by unanimous verdict, meaning all 12 have to agree on whether the state proves your guilt. Now, if you did not want to have a jury trial, if you did not want to plead guilty, then you can waive, which means in the legal sense to give up in writing, the right to have a jury trial. In that case, you would have what's called a court bench trial, meaning that instead of a jury hearing the evidence, it would be the judge who hears the evidence, the judge will apply the law, and the judge will decide whether or not the state proves your guilt or proves guilt on that one. You understand that?
Yes, sir.
Right now, under the Constitution, you have the right to confront witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come in to court and testify in public in front of you, your attorney, and anyone else is present. After the prosecutor is done asking questions, your attorney has the right to ask questions. That's called cross-examination. And the purpose of that is to try to bring out evidence to help your side of the case. You understand that?
Yes, sir.
Right now, under the Constitution, you have the right to use the power of this court to compel or force witnesses on your behalf to come into court and testify for you, which like to say. So if you have witnesses you're uncertain going to come in voluntarily, it's your request, the court issues court orders called a subpoena, and that will force those witnesses to come to court to be able to testify if one of them to, even though they didn't want to be here, which is the same way the state's witnesses are required to come. You understand that?
Yes, Your Honor.
Right, under the Constitution, you have a privilege of self-determination, Mr. Bill, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can, the judge can, if you decide. If you decide not to testify, the fact that you did not testify, not used against you in any way, with any person, at any time, no one's even allowed to talk about it except in one situation. That is, if there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Right now, under the Constitution, you are presumed innocent of these charges until proven guilty by the state of Ohio on every essential element of the offense charge. What that means is that the burden of proof isn't on you to try to show that you're not guilty. The burden is upon the state to prove that you are. So you don't even have to present any evidence to trial. You may, but you're not required to. Whether you do or not, the burden of proof remains upon the prosecuting attorney and the state to prove your guilt or prove beyond reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Now, originally entered plea not guilty to this charge, Mr. Hill, plea not guilty, denied the allegation of the indictment, denied you committed any crime, and exercised or invoked all the rights I've just described for you this afternoon. If you change your plea from not guilty to guilty, that's the opposite of not guilty. Or you plead against the allegation in the indictment, this is their crime, but you committed that crime. That plea waives up all the rights I've just described today, except the right to have an attorney. You always have a right to have an attorney, no matter what your plea is. That exception, your plea of guilty waives up the right to a jury or court trial, waives up the right to probable witnesses against you, and cross-examine for your attorney, waives up the right to use power of the court, fellow court witnesses to come to court to testify for you, same for the state. Waives up your right or your privilege of self-determination because you're the one saying you're guilty, that's what you find guilty. Waives up for presumption of innocence because the state guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court, and finally, it waives up any right to file appeals that you may have had until this point in the case. Now, if I should sentence you back to the circumstances to file an appeal, that would have to be filed within 30 days of your sentencing after you file. You understand all that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Now, Mr. Hill, do you have any questions about the plea of possible penalties in this case?
No, sir.
You understand them?
Yes, sir.
Any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
Any questions about the constitutional rights of this claim?
No, sir.
You understand those?
You see, I repeat that, sir.
Do you understand those?
Yes, sir.
You have any questions about the plea of guilty, what it means, what will happen if you have that plea here today?
No, sir.
You understand that?
Yes, sir.
Now, I didn't say anything to you earlier, but since you're not here at court, you agree to have this court proceeding by Zoom rather than coming back, right?
Yes, sir.
Okay. Do you need to talk to Ms. Barber about anything? Because if you do, I can put you in her into a breakout room to talk privately.
No, sir.
Okay. You have any questions at all about anything I've asked you today?
No, sir.
Then is it your decision to withdraw your not guilty plea and plead guilty to the charge, so the terms of the agreement was just not over, Mr. Hill?
Yes, sir.
The next is the charge which alleges in honor about June 7, 2021, in Highland County, Ohio. You did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, in violation of section 2925.03A1, charged of aggravated possession, aggravated trafficking methamphetamine, a fourth-degree felony, carrying possible prison term between 6 and 18 months, and fined up to $5,000, possible license suspension 6 months to 5 years. How do you plead?
Guilty, sir.
Right, the court finds on this date of court, defendant applies all constitutional rights and no intelligent voluntary waiver of the same pursuant to Rule 11. The pleas exempt or filed offense found guilty of the charge. Count 2 is dismissed. Now, inasmuch as there's a request for a pre-sentence investigation, since I just sent in a couple months ago down with the star, I don't really think we need to have an updated pre-sentence investigation for this party to consist of. Ms. Barber? Alright. The court then has proceeded sentencing. Anything regarding sentencing, Mr. King?
Only those conditions play a very good role.
Alright, Ms. Barber?
Mr. Hill really is doing a lot better. For the first time I've known him until now, there's a huge difference in his demeanor, his attitude, the way he deals with just everyday conversations and discussing his case and speaking matters. He is doing a lot better. I spoke with Allie Robinson at Star today, and reporting he's doing well, and he's expected to get out soon.
Alright, Mr. Hill, anything you'd like to say?
Thank you very much for sending me here. It's a good opportunity. I'm taking a lot from it. I've got my high school diploma. I got a big place in the trade. I appreciate everything.
Alright. Well, then it's objectable to the court that you be sentenced to a term of 3 years of community control under the Highland County Probation Department. These kind of basically the same as your other case, but I'll just go over briefly. First of all, the 3 years, you'd be under community department bail laws, law of jurisdiction, so that's yourself along the way, at all times. Court when as directed. Be truthful in all statements you make to the probation department about your conditions. You're keeping informed of your residence, place, and employment all the time, and not change items without prior permission. Not permitted to leave the state of Ohio at any time without prior written permission. You're not permitted to enter on the grounds of any correctional facility of any jurisdiction, nor to communicate with anyone or attempt to communicate with anyone who is an inmate in this facility without prior permission. You may not purchase, possess, own, use, or have under control any firearm, ammunition, or dangerous ordnance. If you do that, that's a violation of both federal and state law, and you can prosecute felonies for each of those offenses. And it's also a condition that you not have those or any other type of weapons while under control. You're not permitted to purchase, possess, use, have under control any controlled substance, drug abuse, or instrument, device, thing may be used to administer them, prepare them for administration unless you have a lawful prescription and a copy of that must be provided, then 24 hours receipt. And also, you want to have CBD oil, fragrant, marijuana, those substances that might mimic those effects. You're submitted to drug testing when and as directed. You may not purchase, possess, use, or have under control any type of alcoholic beverage, nor may you be present in places of sold or being consumed even if it's otherwise lawful. Not permitted to associate with anyone who might be a co-defendant or any other person that has a criminal record, member of gang, or a person who has a past good future close to commit criminal offense under violation of conditions unless that's approved by a supervised officer. After the date of this order, you're not permitted to marry or establish cohabitation or common law marriage type relationship with others without written permission. You must report any contact law enforcement or any arrest, citation, conviction, or other charge violating the law not later than the next business day that occurs. You must provide your supervising officer with financial information records or your ability to seek pay future costs of your review. You're referred by the probation department in an evaluation session for further treatment or counseling or training, education program, etc. You must submit to that. There's a recommendation for programming to enroll in and complete that successfully. You're paid court costs and pay arrangements to do this. In addition, you'll be required to successfully complete the STAR program ending after here. And I would recommend strongly that you do some sort of transitional housing or something of that nature, because people going out in the STAR program going right back to where they were going to live before, whatever, a very high rate of relapse and going to prison. So we want to try to continue as much aftercare as possible. Now, by being put on pre-control rather than being sent to prison, you're needing sent to a search without a warrant. Your person, your vehicles, your residence, or any other property places or vehicles that are under control used by you, where you're found at any time, any officer of the probation department. Not be required to pay a fine if you know driving suspension imposed. You are ordered to pay restitution, amount of $25 by the county task force through the victim restitution escrow account, the victim's office, and pay a certain fee that's associated with that, which I think is $5. The court costs are also ordered to be paid as a separate order. If you don't make payments on those, clerk could collect that in various ways, could let a bank account or other assets you may have. If that doesn't collect it, then we refer to collections. You have to pay an additional 30% of what you owe on cost, or the court would order you service in this county and give you credit for each hour you work. Each hour you work will reduce your judgment by that amount until paid. Now, in the event that you are alleged to have failed to comply with these conditions, and the probation department filing with those on the court, you can copy and keep out of that hearing. At the completion of that hearing, the court could revoke your control and sentence you between 6 and 18 months in prison and fine $5,000. If that happens, once you complete that sentence, the law provides that self-control authority may, again, their option to push you under post-release control for a period of up to 2 years. They don't have to, but they can with decisions there. So they do. You'll be supervised in the terms they set, and after that period of time they determine that you have failed to comply. They will return you to prison and make you serve an additional period of up to 9 months for any single violation, although there is a cap of half of every prison term served all violations. However, if your violations they do felony, then in addition to whatever sentence the judge in that case would impose upon you, that judge is also authorized to sentence you in this case to committing that offense while under supervision in this case to an additional period of 1 year, or whatever time's up on the period of post-release control, whichever is greater, that occurs as sort of consecutively with the sentence in the case. All right, is there anything further from council? All right, then you're off pretrial supervision, and that will complete your case, and we'll continue then with start program. Goodbye. All right, Ms. Barber, you represent Amber Robinson. Is that?
Yeah, it's just in the law library, so I'll be right.
Okay, that's going to be in person, right? Okay. All right, I think that concludes our Zoom document.
Yes, sir.
As we have anybody else?
No, sir.
Nope. Mr. Lightner's here. Mr. Lightner, Bill?
Yes, sir.
Tuesday, October 4th, State of Ohio versus Austin Lightner. President of the state, Assistant Prosecutor King, minutes attorney for the Arms trial, the Austin Lightner.
Yes, Your Honor.
Okay, Mr. Lightner charged with aggravated possession of 1753 felonies. I've been presented with a plea agreement, Mr. Lightner, which indicates you're going to withdraw your not guilty to the charge of aggravated possession of felonies indictment under 25.11. Vice President, three felonies for the state's to understand the maximum penalty for that is prison, and prison for 12 months, and 56. Fine bail of $25 off license, and 6 months, 5 years. You understand that?
Yes, sir.
On page 3 of the signature lines, just about halfway down the page, on page 3 of the sentence, it says, I heard the plea voluntarily, and underneath that, there's a signature line, and that your signature level can.
Yes, Your Honor.
When did you sign this agreement?
It's about 1:30.
And did you go over with your attorney before you signed it?
Yes, Your Honor.
Did he fully explain everything to you before you signed the agreement?
Yes, Your Honor.
When you came here today, did you understand this might be a possibility of entering into an agreement?
No, Your Honor.
Do you feel you had enough time to consider this matter, or make a decision?
Yes, sir.
Do you feel you've been rushing or pressured anyway in doing this?
No.
You're entering into the agreement legally voluntarily.
Yes, Your Honor.
Now, as I explained to you, the charges on penalties, are you basing any penalty charges in any other jurisdiction?
No.
Are you currently on probation, community control, post-release control, or felonies from any jurisdiction?
Yes, Your Honor. This one.
In this court?
Yes.
All right. Other than that, are you basing any felony, or are you on control in any other court?
No.
All right. Now, was this offense committed before or during the
I'm fairly certain before, Your Honor, right around the same time. In fact, this might have occurred, he was picked up on a warrant out of a previous case, but I don't have that file in front of me, so I'm not certain.
Okay. Let's see. That requires 2021. This is the impact on that.
And I think he also was convicted of failures of here.
They don't have that discovery.
It doesn't show them
I
discovery.
might be thinking of failures in here. I don't know why.
Says, misdemeanors and theft firearms. Is there also a failure here?
I don't see it in the discovery. He doesn't believe he had, Your Honor.
Okay. All right. So, yeah, this case, in that case, it was 21 CR 54. Ironically, this case is 22 CR 54. Hopefully, it won't be 23 CR 54. Because if there is, you'll be going to prison. The reason I'm bringing it up is because under the law, if you should be convicted of this offense and sentenced to prison, and then sentenced to prison in the other charge as well, then those sentences will be ordered and served consecutively, one after the other. You understand that?
Yes, Your Honor.
And you have no other charge of anything anywhere else.
Not that I'm aware of them.
All right. Now, under the law, if you are sentenced to prison for this offense, once you complete that term, the adult parole authority has the option of putting you under post-release control for a period of 2 years. They don't have to, they can, if they do, then you will be supervised in the terms they said. If they determine that you have failed to comply, they can return you to prison to serve the entire term before by the court for an additional period of up to 9, or in this case, 6 months after the prison term for one or more violations. But there's a development on the post-release control that in addition to the sentence judgment, the case of both parties, the judge will also authorize the sentence. In this case, do an additional period of 1 year, there comes that on that period of post-release control, the case period. You understand that?
Yes, Your Honor.
And we'll give that, yes, I'm in the previous case. What do you want to see here? Now, the charge alleges in this case that on or about July 27, 2021, this county, you only take, possess, or use station 2 control substance and felony violation section 2925.11. That's the charge of aggravated possession of methamphetamine. You understand the nature of the charge, what the state's indicated, or how the legend did?
Yes, Your Honor.
We discussed the nature of the charge, the evidence in the case of possible legal issues, the case of possible potential contract raise trial, possible outcomes of a trial with your attorney.
Yes, Your Honor.
Are you satisfied with the advice and comments in this matter?
Yes.
Are you under the influence of attack drugs or alcohol?
I'm sorry.
Are you under the influence of attack drugs or alcohol this time?
No, Your Honor.
Are you taking any prescription drugs?
No.
Has anyone threatened you to plead guilty here today?
No, Your Honor.
Now, on page 2 of the agreement, it states, defendant shall plead guilty to indictment, stating on opposed to control treatment. Is that your understanding of the agreement?
Yes, Your Honor.
You don't promise anything other than that in case you plead guilty?
No, sir.
The law, of course, not required to follow the recommendations of the state. So if you, and your attorney, so in the event that you plead guilty, once I've heard all the information, I decided, despite the 2 recommendations, that that's not the correct sentence. I could choose to send you to prison for between 6 to 12 months, $25 inside, and suspend your license for 6 months. I understand that.
Yes, Your Honor.
Right now, you don't have any license certification from any state agency, governmental agency, that regulates any occupation or profession.
No, sir.
And you got a constitutional right to understand for it, except please when you first have a right to have counsel to determine about the authority to represent you, not simply to work the case out and provide whatever defense might be available to you at the law, which would like to provide. So, you decide you don't want to plead guilty, that you want to fight the charge, we'll continue to defend you until the trial, that's what you want. You understand that?
Yes, sir.
Now, under the Constitution, you have a right to have a jury trial in this matter, which 12 people, these elected citizens from this county that are summoned for jury duty in your on your trial. After they're selected, The evidence to be presented, they instruct them along, and that jury decide, whether or not they say approved jail, approved jail written down. That verdict would have to be unanimous. All 12 of them would have to agree. You understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a, right to, confront the witness against you and cross-examine through your attorney. What that means is that the witness against you have to come into court, testify in front of you, your attorney, and anyone else in front of you. Prosecutor then asks you questions, your attorney asks questions, that's called cross-examination. The purpose of that is to bring out evidence to help your side of the case. You understand that?
Yes, Your Honor.
Right, under the Constitution, you have a right to use the power of this court to help enforce the court testify on your behalf, same state. So if you have witnesses you're not certain when you voluntarily request for you court orders to subpoena, and forces those witnesses to come to court and be able to testify if you want them to, but they don't want to be here, same way the state's witnesses are required to come to court to testify against them. You understand that?
Yes, Your Honor.
Under the Constitution, you have the privilege of self-determination in this matter, which means you cannot be forced to evidence in this case at any time through the trial. So no one ever made testify. The prosecutor can, the judge can, it's your decision if you decide not to testify. The fact that you did not testify cannot be used against you in any way by any person. Once he's not comment about it, except in one situation. There's a jury trial, you do not testify, the judge instructs the jury that because it is your right, they cannot consider it for any purpose. You understand that?
Yes, Your Honor.
Right, under the Constitution, you have presumption of innocence, which means that you're presumed innocent of being proved guilty in the state of Ohio. Every potential obligated against charge. So the burden of proof is on you to try to prove you're not guilty. The burden is on the state to prove you are guilty. And they don't do that by proving beyond a reasonable doubt on every potential obligated against charge. The highest burden of proof is on the law. You understand that?
Yes, Your Honor.
And he originally pleaded not guilty, was denied the allegations in the indictment, denied committed a crime, and exercised all the rights that I've been described. If you change your plea from not guilty to guilty, that is simply also not guilty plea. If the allegations in the indictment necessary crime, you should get that. And that plea waives up all the rights that I just described for you, except the right to have an attorney. Always have a right to have an attorney no matter what you plead. But with that exception, your plea guilty, waive give up right for a jury or court trial. Waive give up right to confront witnesses against you and cross-examine them in the court. You waive give up your right to use the court to help enforce the court that's on your behalf, same as the state. You waive give up your privilege of self-determination because you're saying you go to this and choose fine. Also waive give up innocent doesn't say go to the state on the part of your guilt. It also subjects you to being sentenced by the court. Finally, it waives gives up any right to file an appeal, which they could have under the current situation of this court case. Could file an appeal if I sent you to the maximum or other circumstances. That appeal had to be filed in 30 days of your sentencing after to be filed. You understand all that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
And you're entering into this agreement to plead guilty long-term?
Yes, Your Honor.
You have any questions about the charge of lawful penalty?
No.
Understand?
Yes, Your Honor.
Any questions about the plea agreement?
No, Your Honor.
Understand?
Yes, sir.
Any questions about the constitutional rights of the claim?
No, Your Honor.
Understand those?
Yes, sir.
Any questions about the plea guilty, what it means, what will happen in that plea agreement?
No, sir.
Understand?
Yes, sir.
Anything about speaking to your attorney about before we went?
No, sir.
And it's your decision to probably not go to plead guilty to the charge, so it's the term of the agreement.
Yes, Your Honor.
All right, and as to the charge, which alleges on or about July 27, 2021, 1910, Ohio, you did knowingly obtain, possess, or use of Schedule 2 controlled substance with methamphetamine, violation of Section 29.5 of the Ohio Code. Any charge of aggravated possession of methamphetamine, fifth degree felony, or lawful prison term between 6 to 12 months, fine of $25, lawful license after 6 months to 5 years.
Guilty, Your Honor.
All right, court minded in this state of the court defendants by laws constitutional right to make no help on third degree sanction of 11, please accept the file. Defendants found guilty of the offense. This is reviewing the pre-sentence investigation that was last August. And actually, it's a little exact. And I'm just looking at that, getting the call, I think what you're saying, like, you're correct, is that we did have one applicant failure to apply, I believe, because he, had been tested positive and referred for treatment, and he had not contacted the treatment provider. And, yeah, let's see, the facts I have here was, you recall what date you sent to the other case?
I believe it was September 21st.
Okay, that's probably about right. Yeah. Okay, I don't have any information from the probation department. Usually, in my case, numbers is good. Just either parties feel that we have updated that percent report.
State has no need for one.
All right. Then the court will go ahead and proceed with sentencing forthwith on the sentence. All right, Mr. Anything on behalf of the state?
Only those containment we agree with, Your Honor.
Sergeant Brown?
And this court filed a language on keep Austin on community control. I don't know if I remember, did I represent you on the theft of guns? I didn't represent him on that theft of guns, but I guess the dates were similar to what was going on here, Your Honor, so we asked the court to keep him on probation.
All right, Mr. Leitner, anything you'd like to say?
No, Your Honor, I'd just like to personally thank you for sending me to inpatient treatment last year because it did help out a lot.
Where is it?
Matt's house.
What are you doing now?
Right now I'm working, I'm in FRS outpatient. I'm trying to comply with everything and just get this stuff behind me.
Where are you working?
Herman's Pole Barns, right outside of
Atlanta?
here. Yes, sir.
Okay, how long have you been there?
Going on probably 2 months now.
Okay. Have you worked there before?
No.
You had no pretty training since get out of treatment?
Yes, I have. I did fail for alcohol at the probation department a couple weeks ago, and I have been failing at FRS for THC, but I need to get my attorney paid, and I am getting the medical card and everything. I know it doesn't help right now, but.
Well, let me tell you, I'm not much of a marijuana card. People that have substance use disorder as you do. And the reason for that is it just doesn't have a self-medicating and 40 situation. The evidence that it has any bona fide medical value is pretty much non-existent. It's all anecdotal where people say, well, I smoked a joint, I felt better. And I say, well, I had a glass of whiskey and I felt better. That's not a cause of that. And so, the probation department knows my position on it, and I'm not much in favor of getting better or getting marijuana because, quite honestly, it's just a BS way in the state making money. It's a legal fiction. So, don't get that marijuana card because if you do, you're going to end up probably violating your community control because and you're also testing for alcohol, so you're still self-medicating, and that's one of the reasons that those are conditions because it's just people looking for another way to try to avoid dealing with reality, altering their mind, getting caught, and that's just not going to help you. So you need to focus on your treatment and back in county now, you're not going to get better than marijuana. So I'm going to go ahead and put you on community control. You can be seated for a period of 3 years, and the conditions are pretty much the same as before. You'll be required to comply with all conditions of the permanent all federal, state, and local laws, and as yourself qualified in there all the time. You must report when and as directed. You must be truthful in all statements that you give to the probation department about your conditions. You are to report when and as directed, be false statements that they give to you, or you make them, as I said. You must keep it informed of your residence, place of work all the time, can't change either without prior permission. I'm permitted to leave the state of Ohio anytime without prior permission, without any correctional facility, or communicate or attempt to communicate with anyone with an inmate in those facilities without prior permission. Now, because of your convictions, you're committed to federal state law, purchasing, possessing, owning, using, or having under your control any firearm, ammunition, or dangerous ordinance to do so would be a felony under federal state law. And you're not permitted to have those under your control, nor are you permitted to have any other weapons. Now, you're not permitted to purchase, possess, use, or have under your control any kind of controlled substance, drug abuse, CBD oil, trailer, medical marijuana card, or any variant or analog, any of those types of substances that would have effects similar to a controlled substance or drug abuse. You may not have any instrument device thing, may be used to administer those for comparative administration, as you have law prescription, you must provide a copy of it in the law. Must report or submit drug testing when as directed. You're not permitted to purchase, possess, use, have under your control any kind of alcohol beverages, nor be present places where the soul will be pursued, keep otherwise lawful. Not associate with anyone who is a co-defendant in this case, and or anyone else has a criminal record, a member of gang, any other type of criminal group, person who has a past with the future. Influence you to commit criminal offense by conditions unless approved by a supervised officer. Under the dangerous order, not permitted to vary, establish cohabitation, couple on very tight relations with another person without permission. You must report any contact law enforcement, arrest, citation, conviction, or other charge violating the law on the next business day after that occurs. Provide a supervised officer with financial information records that are ability to pay the fees and costs to be reviewed. You're referred for evaluation assessment, ready for the type of treatment, therapy, counseling, training, or other education program. You submit that, and if there's additional programming recommended, you'll enroll in and find that to be successful. Pay court costs of this action and make paper arrangements to do that. Or, now you'll be required to successfully complete the FRS program. That's where you're at, right? FRS.
Yes.
And any additional aftercare they may recommend. And one of the things about medical marijuana and drinking, one of the reasons because is that lowering the affecting people's minds and making them more susceptible to being criminal offense. The other thing is that your employer probably doesn't want you to use medical marijuana or drinking because it would cause an accident in working in construction pole. It's dangerous work, that it's done correctly, it's not, you can't do it in a dangerous condition. And the other thing is, if you have either of those in your system, then you can't have a job, maybe prevents you from getting workers' comp. And so you need to just understand you don't need to do those things. It's just going to be suppression. You need to put some in your ready, work it out, and walk it off, and be able to walk it out. It's just suppression. Now, in any event, if you fail to comply with these conditions, then the adult or the probation department will file a written notice of report. You'll be given a copy, and you'll be out of that hearing. Out of that hearing, if you fail to comply, at that time, the court can revoke you to control sentence you to prison. In this case, for between 6 and 12 months, and fine you $2,500. If that happens, then on completion of that prison term, the adult parole authority could decide which what's called post-release control supervision for a period of 2 years. And if they do, they determine that you have failed to comply and they can return you to prison, you may serve the entire term set in court for an additional period of 2 after the prison term, one or more violations. However, if you are convicted of felony, then an additional whatever sentence the judge in the case of that judge is also authorized to sentence you for committing that offense while under post-release control. This case, an additional period of 1 year. Whatever time left on that period of post-release control shall be greater. And if that occurs, that's to be served consecutively sentence in the case. there won't be any fine or suspension of license. You are, will pay court costs and such. If you fail to do that, then the clerk will collect that conversion, exclude medical bank accounts, wages, and earnings, may have, or assets may have, that doesn't affect it. Then the clerk puts her go to collections, that pay 30% on top of what you owe cost, or the court for you to do service, you can correct each other work, and they're not going to raise that, but each other work, reduce your total by that amount. All right, is there any further counsel?
They are.
After police, in case you're no longer on pretrial supervision, you report to the probation department immediately after court, since you down here, so that will should be trained. This case is also the added to the case you're already on. And you need to be seen on that, this case law, point for you, we'll get into the next case, or the next point, just go down today, let them know. All right, thank you. And Andrew Robinson. Case number 22-CR69, State of Ohio versus Andrew Robinson. Attorney on behalf of the state, Assistant Prosecutor King. Attorney on behalf of the defendants, Attorney Sir Barger. Are you Andrew Robinson?
Yes, Your Honor.
All right, Ms. Robinson entered a plea of guilty to committing drug abuse and misdemeanor felony. Matter was referred for a pre-sentence report. I have received that through the police of the attorney received the summary.
Stay out of your way.
I have not, Your Honor. Unfortunately, I was running a little late today, so I have not had a chance to look at it.
All right. All right. Ready to proceed?
Yes, Your Honor.
All right. Mr. King, anything that like that say?
Only was contained in the plea agreement, Your Honor.
Ms. Barger, you asked for the consent.
Just what is contained in the plea agreement, Your Honor. I would also point out that she has started services at FRS.
Robinson, anything you'd like to say?
I would just like to apologize. I'd like to apologize that what has went on. It'll never happen again. I just want to say sorry.
And you received your first Suboxone?
Yeah, Suboxone. No, not the shot. It's Suboxone. Just the pill.
And trying to look here treatment.
At Rosemont Clinic,
Rosemont Clinic, that's in
Chillicothe. Yes.
Is he just, giving you the, prescriptions, or are you doing counseling there?
No, I'm doing the counseling at FRS,
Oh, okay.
2 days a
Oh,
week.
there it is, I see that there, okay.
Yeah.
Well, I didn't realize you were, one of these, I graduated high school, Connie, I've been dad, his family for many years, I don't know if that's you. I've seen it for quite a long time. You had some history here, I see you, used to be a nurse, you don't have a license now, right?
Yeah, I do actually have my license. They're suspended though.
This is been,
Yeah,
all right.
they're
So I
suspended.
don't have to think of the history you sent to, nursing. All right, well, it's order judgment of court that you be, sentenced to a term of 3 years of duty control supervision. Under the following conditions: first year bail, laws, all jurisdictions, exercise law, right, and no crime. Must report when as directed. Must be truthful in all statements you make to the probation department regarding your conditions. Must keep it before your residence, place, and employment all the time. May not change either without prior permission. Now, leave the state of Ohio at any time without prior permission. You may not enter upon the grounds of a correctional facility, nor may you communicate with or attempt to communicate with any person who is inmate in any of those facilities without prior written permission, includes right. Now, you're not permitted to purchase, possess, own, use, or have under control any kind of firearm, ammunition, dangerous, ordnance, weapon, of any other type. And I'm not positive, but I think the video drug abuse still qualifies as a disability under federal and state law. I could be wrong about that, I'm going to tell you for purposes of putting you on notice that if that's the case and you were possessing those in the future, you can be prosecuted for addition of. You can't have that disability removed if it is in fact a disability by future legal proceeding that consult with an attorney about that. Now, you're not permitted to have any of those items while under control item. You're not permitted to purchase, possess, use, have under control any kind of controlled substance, UCB, oil, grade, or analog, any controlled substance that affects similar to controlled substances, drug abuse, or anything that can be such as a device, instrument, to be used to administer them or prepare them for administration. Unless you have a lawful prescription, then you must provide a copy of that within 24 hours. You must submit to drug testing when it has directed. You may not purchase, possess, use, have under control any kind of alcoholic beverage or be present in a place where the shoulder being consumed is otherwise lawful. May not associate with anyone who is a co-defendant in this case or any other person who has a criminal record, member of a gang, or any other criminal group. Any other person who has a past or good future which is commit a criminal offense to violate these conditions, unless that's approved in writing by your supervisor officer. And you may not, after the date of this order, ever establish co-habitation with Commonwealth marriage type relationship with another person without permission. Must report any contact law enforcement after arrest, citation, conviction, or other charge of violating the law, not later than the next business day after that occurs. You must provide your supervising officer with financial information records or ability to pay fees or costs to be used. If you're referred by the probation department for any evaluation or assessment for further treatment, therapy, counseling, training, or programming, you'll submit to that if they recommend any kind of programming. Your enrollment is successful with that. Pay for court costs. This action may rate do that with the clerk. You'll be required to successfully complete the FRS substance use disorder program and aftercare. And that means also complying with the medical assisted treatment program. Now, by being placed on due control rather than being sent to prison, you're deemed to consent to a search without a warrant. Your person, your residence, vehicles, unveiled, used by you, or any other property places under your control, or that you use to where you're found at any time, any officer of the probation department. Now, will be notified and required to pay more any right of suspension. Will be ordered to pay court costs, and if you don't, then the clerk will collect that by very including the bank, that's what it assets you have. If that doesn't affect it, then, clerk could turn over questions to be part of a 30% of population vote, or for you to service, if you correct each area work, and rather than that before. Each area work will reduce your judgment by that amount, and so it's paid full. Now, in the event that it's alleged that you have failed to comply with any of these conditions, then the probation department will file a records of that, serve a copy on you. They'll have a hearing, and the entire will have a return. The outcome of that hearing is that you have failed to comply, and at that time, the court will revoke community control, sentence you to a period of 26, 12 months in prison, fine you $2,500. If that happens, once you complete a prison term, it is possible that the adult authority will choose to police control supervision for a period of 2 years. Absolutely can. But if they do, and violate those conditions, they can return to prison so it's the entire term by the court for an additional period. But in this case, half of your prison term for one or more violations. But if you commit a new felony, then an additional represents a judge in litigation imposed on that judge is also authorized to sentence you for committing that offense while under community control, police control in this case, to an additional period of 1 year, whatever time you have left on your period of police control, whichever is greater. That occurs as we serve secondly the sentence in the case. All right, is there anything to the council?
No, no.
Ms. Robinson, you're no longer on pre-trial supervision, house arrest, that kind of thing. You get the new conditions, you need to report probation department immediately after the hearing court telling you the sentence and need to be transferred to felonies.